All right, good afternoon, and thank you all for joining us today for our November webinar. What is the difference? VAWA versus Minnesota Statute 504B.206. My name is Ana Maria Studer, and I'm the Advocacy Support Program Manager at Standpoint. My role today is going to be to help facilitate the webinar. Just to let you know, this webinar is being recorded, and you will be able to check it out on our Standpoint's YouTube page later on. Also, the link for the recording is going to be emailed out to our listserv. I will put in the chat box the link for the PowerPoint that would be easier for all of you to follow along. If you have any questions during the webinar, please type your question in the Q&A tab, and either our presenters will pay attention to them or I will pass the questions to them. Most of you already know probably about our organization, but for those that listen to this later or those who don't know, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to system professionals who work with survivors, and we do this by facilitating trainings and answering calls through our action line. Examples of the trainings that we do are the annual new laws throughout the state of Minnesota, the monthly webinars for advocates like the one that we are presenting today, and we do other trainings by request. Our action line is answer Monday to Friday from 9 a.m. to 4 p.m. And it's going to be through this action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources. We do safety planning. We listen and help callers identify possible options and next steps. Our presenters today are our amazing housing team, formed by Bailey Hovland, staff attorney, and Raylene Caswell, that is our housing advocate and supervising advocate. Now it is my pleasure to welcome Bailey and Raylene to get us started.
Thank you, Ana Maria. Ana Maria is one of our many staff members on the action line. So if you've called Standpoint, it's more than likely you've probably spoken with her before. She also coordinates our webinar. So if you ever have things that you'd be curious about learning more about, or that you think would be important to learn more about, feel free to let us know, and we take that feedback seriously. So as Ana Maria said, my name is Bailey. I am one of our two staff attorneys at Standpoint. I am also the attorney who does housing law. So if you have housing related questions, it is more than likely you will get funneled to me. Raylene is our advocate. Go ahead,
Yep.
Raylene.
Beautiful. Thank you so much. Welcome, everybody. My name is Raylene, she, her pronouns, and I'm a housing advocate. So I'm the one probably funneling things over to Bailey as it comes to any kind of housing concerns. And we are super happy to kind of talk a little bit today about the difference between VAWA, the Violence Against Women Act, and my personal favorite statute, 504B.206. I think these are two really awesome ways to do some really good advocacy for folks. So excited to jump in. Ana Maria did a little bit about who we are, but just as a brief overview, we were formerly known as the Battered Women's Legal Advocacy Project, changed our name a while ago to reflect the fact that anybody can experience domestic or sexual violence regardless of identity. We have our attorneys and advocates who are here to provide legal advice if you're an attorney, and legal advocacy as an advocate, and different kinds of safety planning and resources. And we like to always remind folks that we are a statewide agency. We provide services to victims and survivors of domestic and sexual violence, as well as the professionals like advocates and other folks who are serving them. And then finally, we are completely free of charge. There's no income guidelines or anything like that, and no intake required for anyone reaching out to us on the action line or via email or in any capacity. So those are some brief reminders about the work that we do here.
All right, so here is an overview of what we will be covering today. First, we're going to hone in on VAWA, which is also known as the Violence Against Women Act. And we're going to talk through the different processes, the different options survivors might have under VAWA, and how you can certify to get those VAWA rights basically initiated into your housing concern or case. Now, For the second act of our presentation, we're going to be talking about Raylene's favorite statute, 504B.206. It is actually one of the only statutes that I have memorized number-wise because I cite it, I think, literally every day. I do not think that is an overstatement, but it is a lease break process that's unique to Minnesota. We'll talk through the basics and the process of how it works, right? How to actually apply this statute in practice. Finally, we're going to take some time to review the similarities and differences between these two acts because we find that they can get intermixed quite often or confused, and it's helpful to know how they're different and how they're similar and who qualifies, right? And then we will practice a little bit at the end, applying our knowledge if we have time. So hopefully we do have time. That's the section at the end that we do intentionally just in case we have a lot of questions or we're really engrossed in one of these sections. So with that being said, we're going to start with VAWA. Like I said, VAWA is the Violence Against Women Act. Many people have heard of VAWA before, right? They might not know about it in that housing context, but oftentimes people are aware that this is a law and that they do some kind of protections, right? For housing, those protections are very specific, and it's important to note a few things about VAWA. So, the VAWA housing protections. The federal law initially passed in 1994. Like I said, it's not a state law. It's not unique to Minnesota. It is a federal law from the U.S. government. This law was passed, and a part of it includes protections for victim survivors in housing situations, right? They wanted to address those problems. And so if someone was a survivor of domestic violence, dating violence, sexual assault, or stalking, then they would be able to certify themselves under VAWA and seek additional possible remedies to kind of help their life along if they've been victimized by those different things. One very big thing to point out that we'll probably repeat quite a few times through this presentation is that survivors who live in just regular housing and pay their full housing value are not going to qualify for these VAWA protections. It's specifically applicable to survivors who live in federally subsidized housing, right? The most common example we hear about is usually like Section 8 housing. That qualifies under VAWA, and I have a list on a different slide showing all of the different programs that VAWA includes. That list is from HUD's website, the federal government. So that is their status on which subsidies count. If you are someone who is protected under VAWA, right, if you qualify, a housing provider has certain things they can't do. They can't deny your admission to housing based on your status as a victim survivor, right? So if you had an eviction on your prior record, but that eviction was due to a severe domestic violence situation, they wouldn't be able, arguably, to deny you admission on that sole basis. If you can prove, no, that was specifically because of domestic violence, I didn't do anything in that situation wrong. They can't evict you based on being a survivor. So a similar thing might be if you call the police frequently because your abuser shows up and is trying to get into your housing, and your landlord says, I just don't want to deal with that. If they're covered under VAWA, if they receive a federal housing subsidy for you living there, they can't evict you on that basis. That's unlawful. They also can't terminate housing subsidies or assistance based on your status. So these are all based on your status as a survivor, right? If they're doing it for another legitimate purpose, they might be able to, but it essentially says, no, we are going to make sure that people are not facing bad consequences because they've been abused by another person or harmed by another person. Like I said, VAWA is an expansive law. There's a lot of other things that are covered in it. So this training is honed in on those housing protections, not on the expanse that is the Violence Against Women Act. All right. I'll turn it over to Raylene.
Beautiful. Thank you, Bailey. So I think with VAWA, this is just kind of, again, to reiterate what Bailey is saying. So first and foremost, VAWA has housing protections available for victims and survivors who have experienced domestic violence, sexual assault, dating violence, or stalking. It doesn't matter if this is a current issue that they're dealing with, there are current safety concerns, it could have happened 6 months ago, there's no time frame. I think that that the time frame matters for us in terms of safety planning. Is there an immediate threat to someone's safety? We need to think about shelter or OFPs or whatever that might be. But in terms of certifying under VAWA and asserting those protections, there is not a time frame in there. If someone had experienced domestic violence, 30 years ago or something, we might have to do a little bit of work to show why those protections are needed, but it's not in the statute. It also applies to folks that are currently experiencing any of these VAWA types of assault. So again, the domestic violence, sexual assault, dating violence, or stalking. And then, of course, again, like Bailey said, we're going to repeat it a million times. VAWA housing protections only apply to folks that are living in federally subsidized housing or applying to live in federally subsidized housing. This includes things if the survivor is applying for living in shelters, transitional housing, permanent housing that are in some way subsidized by federal assistance programs. So that's a lot of the folks that we work with as well. And then a big question that we have a lot of times is, does the victim survivor have to be married to or related to or living with the perpetrator? And the answer to that is no. So we know that people are often sexually assaulted by people that they don't live with or might not be married to or whatever. So as long as they have experienced these types of violence, they're living in federally subsidized housing or applying to live in federally subsidized housing, they would be able to assert these protections under VAWA. If they are trying to move into, kind of a standard market rate rental, then these VAWA housing protections would not apply. So, good things to keep in mind and questions that we do have to ask people when thinking about their housing protections and options available to them.
All right, like I referenced earlier, the federal government provides a specific list of the subsidies that are included. So if you hear of a subsidy that you're not super familiar with, working with a person with, this is the place to go. You can literally go to the federal government's website and see what they're supposed to be following the rules on, right? So public housing is one, home investment partnerships, emergency solution grants. These are all linked in this slideshow, and we have a PDF version of the slideshow available after the presentation. So feel free to use this as a resource as well. Obviously, my legal advice is always to check the federal website because things can change. But as of the date of this presentation, or at least when I looked at the federal website yesterday, this is the current programs that are covered under VAWA.
And I think too, a lot of times if you're asking a victim survivor, hey, do you have federally subsidized housing? Nobody knows what that means. So you can ask them, do you have a housing program? How much do you pay for rent? Do you have someone that you have to provide your income to on a monthly or yearly basis for your housing? So questions like that can help us get to that answer because nobody knows what federally subsidized means. That's okay. We can help be curious about that and kind of dive in a little bit further.
Yes, absolutely. And I love an opportunity to learn because the more I learn, the more I can know about the next survivor that I might need to help. So, absolutely agree with that. We sometimes have to come up with creative ways to figure out the information that we need from our clients or our callers, right? So, good note for professional practice. Um, so, if you've qualified under VAWA, right? If you are a survivor of one of those four different things Raylene listed on the prior slide, and you have asserted your protections, which means you've certified yourself, and we'll talk about that in a minute, what that looks like. You get certain protections under the law, right? So you can't be denied admission or assistance for one of these programs solely based on your status as a survivor. You can't be denied admission, evicted, or have assistance terminated, right? They can't take it away because I'm a survivor of these things. And that's what I was referencing earlier about like eviction records that are specifically related to domestic violence. You might have to do some groundwork and provide paperwork to demonstrate that if you're able to. But again, if it could give you additional protections, that's something you might want to pursue. Same thing with like criminal history, bad credit. If you can tie that to the domestic violence and show that that was a result of it, then technically they are not able to utilize that to deny you housing, evict you, etc. Like I said, you have to be able to provide the housing provider with some form of certification. We'll talk about what that looks like, but you can provide verbal certification. A landlord doesn't have to accept it though, and my practice as an attorney is that I love documentation, which I'm sure if any lawyers are in the room, they will echo that sentiment. So my recommendation is always to do written VAWA certification, just so that you have a form of proof if you would ever need it, right? You get to select that form though. You get to select the form of proof that you want to provide. Some housing providers can be more difficult than others, but that's the law technically. And again, we'll talk about that in a little bit more length later. Landlords who accept funding from these federally subsidized programs have to give a tenant the HUD's Notice of VAWA Housing Rights and the HUD's VAWA certification form. That is a requirement. Not everybody does it, right? But that technically would be a violation of VAWA and is something that might need to be looked into to make sure that they're providing that information. It's very important for people to understand what their rights are under our laws, right? And this comes into place when either they're denied admission to that program or they're admitted, right? I am accepted to have a lease at your apartment building, or they receive notice of an eviction or termination. Once a survivor has certified themselves under VAWA, they have a strict right of confidentiality of their information regarding their status as a survivor. That doesn't mean everything, right? But it does mean that the documentation they use to provide to show that they qualify under VAWA, that certification document, that needs to be held in a protected place. It can't be stored with other files that could be accessed easily. There's very specific protections. Now, that doesn't automatically mean that your name can't appear anywhere else in their records, but it's specific to any documentation related to your status as a survivor. Those records need to be kept separately and very confidential. Finally, a landlord cannot coerce, intimidate, threaten, or retaliate against someone for seeking VAWA protections, right? That's not acceptable and would be another violation of VAWA. If I'm already seeking those protections and they are trying to stop a person from doing that, that is not legal.
Hey Bailey, if someone is a victim survivor of one of these types of violence, can they be evicted at all?
No, not under those types of violence, right? If it's only based on the violence, not under Minnesota law or not under federal law. But if the landlord has a different separate reason that would be a legal reason to evict them, then yes. So if it's at all predicated on their status as a survivor, that's concerning, especially if that's the main one. If that's the main reason they're being evicted, no. But if it's because they haven't paid their entire amount of rent for a few months, that would be a legitimate basis, right? So if it's a regular lease violation, that would be expected to be leading to an eviction action. But if it's anything based on your status as a survivor, that's where your protections might come in. Great question, Raylene. Okay, I'm going to turn it back to Raylene to talk about what options we might have.
Yeah, so when we're thinking about VAWA, we've experienced this type of violence and we're looking to explore what options might be available to us for our housing. There's a couple of things that VAWA can help us do. So again, first and foremost, we do have to, again, ask if the person lives in federally subsidized housing. And we always want to look to VAWA options first. We will talk about, again, my favorite statute, 504B.206 in a second. But for anyone who has federally subsidized housing, we want to look first to VAWA options because VAWA has a little bit more flexibility in some ways and different kinds of options available than just breaking a lease. So VAWA does not, in and of itself, break a lease. It does change a lease later, depending on what options are thought about, but it is not specifically to break a lease. So the options that are under VAWA include, first and foremost, an emergency transfer. So this is something that a victim survivor can request when they are certifying under VAWA. And they can say, essentially, it's saying, landlord, I live in this home. I'm not safe here because I've experienced one of these VAWA types of violence, and I would like to move. I'm not safe. I don't want to be here. So they can learn about what options are available as an emergency transfer. Sometimes that means, depending on the kind of subsidized housing they have, it might mean looking into a different unit in the same building, or the building across the street or something like that. maybe they have a voucher, like a Section 8 voucher, and they have to find their own housing. So there's kind of different options depending on the person's subsidized housing, and what that looks like. So we always want to make sure we're touching base with the housing provider, the housing program, whoever's kind of running the show, and kind of managing that subsidy to find out what that looks like and what kind of options might be available to them. The other thing is that an emergency transfer sounds fast, often isn't. Unfortunately, there just isn't enough housing. Federally subsidized housing requires a lot of paperwork and the government red tape and things like that. So it's not a fast situation. Depending on the type of housing or anything like that, it could be faster than others. But this is where really good safety planning is going to come in, as we're working with folks, to make sure that they are safe through this process because it could take several months depending on the type of housing that they have and what options are available and what their voucher pays for or whatever they're looking into. If the survivor has a Section 8 housing choice voucher, they must be allowed to move with continued assistance, which is a big one because I think lots of folks we work with have the Section 8 vouchers, so keep that in mind as well. Something else that you can do under VAWA is called a lease bifurcation, to remove a perpetrator from the unit or from the lease itself. So a lease bifurcation takes one lease and puts it into two, essentially. So this would mean that the perpetrator would be removed from the home. In order for both folks to be eligible for housing going forward, the victim survivor still has to qualify for that type of housing support. And that can really depend, especially depending on who has the income for that household. And then the perpetrator, the abuser, would also have to qualify on their own as well to separate those households out. This process can take time as well because they can't just walk into the unit and say, okay, abuser, you got to go. There has to be a formal process in place. And this can really be a huge safety concern for someone who's living with their abuser. And the abuser has then found out that they are essentially being evicted from that home. So that can be really unsafe. So being really, really careful when working with folks that are doing that lease bifurcation. It can be a really good option, especially if folks maybe have an accessible unit that works really well for them. They're really comfortable in their home, or they don't have the means to kind of move to a new space. That lease bifurcation can be a really good option to consider. And then finally, they must be allowed to stay in their residence. So a lot of times we hear from callers who will say things like, there was domestic violence in my home and I'm being evicted, things like that. A victim survivor must be allowed to stay in their home, even if there has been criminal activity related directly to that type of abuse. So the domestic violence, sexual assault, dating violence, or stalking. So those are the three options. It's not a lease break. It does change a lease. Of course, if you're doing an emergency transfer, you're going to end up with a new lease. Same thing with a lease bifurcation, you would end up with a new lease. But it is not the same as a lease break under the Minnesota statute, which we will definitely talk about as well. So it gets a little bit tricky and kind of confusing sometimes, but it's important to keep in mind that it is not a lease break in the same way that the Minnesota statute allows. The biggest thing when it comes to VAWA and exploring these different options is to absolutely stay in touch with the housing provider. So it gets to be a lot to coordinate sometimes because there's going to be the housing provider, there might be a landlord, there might be a new landlord to talk to. So there's kind of a lot of professionals involved. But it's really important to stay connected with that housing provider to find out, one, do they know about VAWA? Do they know what an emergency transfer looks like? What is the process? How do we do it? And what kind of options exist? If you live in a place where there are four, available units, that emergency transfer might not be the right option for you. It kind of depends on, again, location, what subsidies are available, what the housing market looks like. But always staying in touch with that housing provider can be super important. And then we also just have on the slide here that victims and survivors have the right to seek law enforcement or any other kind of emergency assistance without any penalty from local laws or policies. And we get that call a lot too of there were too many police calls at my place and now I got evicted or something like that. But victims and survivors always have that right to seek emergency assistance without penalty.
right. So we've talked about what VAWA is and what it can do. How do we use it? Um, a survivor, like I said, can certify verbally. My legal advice is do not do that, because a paper trail can be wildly helpful if for some reason someone ever said, no, you didn't tell me that information, right? It's much harder to argue with a piece of written documentation showing what that information was. So, although you can use it that way, my advice would be to do so in writing. Now, even if you wanted to verbally certify under VAWA, if the housing provider requests written certification, then you have to comply with some form of written certification. However, the housing provider cannot specify what form of written communication you use under this law. This law delineates certain things that can be used to certify under VAWA. The form I recommend is the HUD 5382 self-certification form. That form was developed by the department responsible for overseeing a lot of these things, and it's pretty easy to understand, I think. If people Google it, they're very quickly able to figure out what it is if a landlord's never seen one before. That's why I recommend them, just because it's standardized. It comes from the federal government. They've been used for a long time, and people might be more familiar with that form of documentation. You can also provide a record of a court or law enforcement agency. So, if, for example, a survivor was a victim of sexual assault and there was criminal charges brought about it, right? They could bring documentation from that court proceeding or from that police report and say this satisfies the requirements under VAWA, but they don't have to provide that information again. This is their choice. It's what documentation is going to be easiest or best for them. Law Help MN also has a form for VAWA that can be utilized. A qualified third party statement can be utilized. It's very important to note that this is not the same as a qualified third party statement in the context of our Minnesota statute 504B.206. They use the same language, but one's a federal law, one's a state law. Our state law requires a specific kind of statement. The federal law doesn't necessarily have that. So just know that they're both similar kinds of documentation, but they are not the same and not for the same thing. Or if the housing provider requests something else to show it, right? If you're like, I don't want to fill out a self-certification form, I don't have a court order, I don't want to fill out the Law Help MN form, and your landlord says, well, if you just give me a written statement saying I need to end I certify under VAWA, I'm the victim of this kind of crime, that'll do it for me. Get that in writing from your landlord, but then you could arguably use that if your landlord accepts it, right? So that's the process. One thing that's important to note is that the same process has to apply for all tenants, right? The landlord can't generally accept verbal housing or verbal VAWA certification and then for one specific person say, well, now I'm mandating written. That would be seen as kind of discriminatory and unfair. So whatever way that the landlord is accepting it should be a fairly standardized process, and you should not be the outlier. But again, the victim survivor gets to be the person who picks that documentation.
And Bailey, I'm just going to jump in real fast. The Law Help MN form is really nice because it also helps incorporate some of the protections that to remind victims and survivors what these protections are in an easy kind of checkbox situation. And it reminds us too that you can assert your VAWA rights as you're applying to places. So I like it for those reasons. That can be really helpful. We have had some landlords tell us this form is made up and weird looking because it doesn't look official. So sometimes, you can use both the Law Help MN form and the HUD form can sometimes rectify that a little bit because I don't know, we've just had weird pushback there.
That's very true. And one great thing about Law Help MN is they actually have attorneys review their documents each year to make sure that they're updated with the law. So that is the good thing about Law Help MN. I am not sure at what rate HUD is developing or editing these forms at all. But like Raylene said, sometimes landlords don't recognize it. The Law Help MN forms are designed to be very user-friendly and to use very plain and simple language, not a bunch of legalese, and that might be why. But again, that's more than that's a total option someone can assert if they really want to use that form of documentation. So if a landlord requires written certification, which again, my general, I'm going to keep reminding this because I love documentation. I would prefer written. Written certification must be dated. That is important, again, for VAWA, but also as an attorney so that we can determine when this evidence was created. When did I certify under VAWA, right? Is it today, November 20th? Was it last week? So make sure to date that documentation. Additionally, if the landlord requests written documentation, right, the survivor says, I'm certifying under VAWA, they said, give me written certification, the tenant has 14 days to provide that documentation. So they don't get to dictate that time frame. A landlord can't say, within 7 days, you better get me these documents or you don't get VAWA rights. That's not how the process works. You have 2 weeks to compile the documentation to certify yourself. All right. Additional documentation can only be required by a landlord when there's conflicting information. Now, that might be hard to prove sometimes, but that is the case. They can't just say, well, I don't believe you and I want more documentation. That's not enough. They don't get to say that. Conflicting information to me usually is they found evidence to suggest that maybe you aren't a victim of the thing you're claiming to be. For example, maybe you use an order for protection to demonstrate kind of some of your fears under VAWA, and you provide that, and your landlord looked up your record and saw that there is an order for protection against you with the same person. Then they might be able to require additional documentation, but they have to make that request in writing, and you again get 14 days to provide that additional documentation. Again, that only comes up if they have conflicting information. If they don't have any conflicting information or any other information not to believe what you're telling them, they don't get to make that standard higher for you, right? That's not how that works for survivors. I talked about a little bit earlier, all documentation about the status of someone as a victim survivor has to be kept confidential. That's very important. It's a strict confidentiality requirement for landlords and housing providers. The documentation itself needs to be saved separate from the main file the victim survivor has, right? It's very specific protections, and it cannot be entered into a database where other people have access. This is not something that basically anyone should be seeing but the landlord internally. So it needs to be kept separate. If a survivor for some reason thought that that was not the case, that could present a big issue for the landlord, that they're not complying with federal law, and it is not usually fun when the federal government is looking into whether or not you're complying with their laws. So important to know for landlords to protect that information, and important to know for survivors that that information should be protected and needs to be protected. All right, I'm going to flip back to Raylene so she can give us our intro to her favorite statute.
My favorite one. So Minnesota statute 504B.206. This is, we commonly refer to it as the lease break statute in Minnesota. And this one actually does break a lease. So we'll talk through what that looks like. So the law was initially enacted in 2007, and there have been a lot of changes to it since. So it's gotten progressively better. Still lots of ideas on how to make it better, working on that. But what it allows is for a victim survivor to break their lease at any time due to fear of violence. And that includes domestic violence, sexual assault, sexual extortion, and harassment, if I'm not mistaken. The biggest piece with this one is that you can, one, break your lease at any time, so you don't have to give a certain number of days notice or anything along those lines. And two, you forfeit your security deposit kind of automatically. There is some contention at the moment about whether that forfeiture of the security deposit gets applied to like past due damages and things like that, or if you forfeit that security deposit in exchange for breaking your lease. So we're working on some changes, legislative changes there to clarify that a little bit. So stay tuned. Hopefully that goes the way we want it to. The victim survivor does owe rent for the entire month in which the lease was broken. So if I broke my lease today, then I would still be responsible for all of November rent. If I broke my lease December 1st, for example, I would have to pay all of December rent. So you always want to be really clear about that with victims and survivors, because they often are finding a new place to move into on the 1st. But you really want to be clear about what that means for having to pay the entire months of rent. And then finally, the lease is broken for all tenants or other authorized occupants. So if you have roommates, family members, if you're living with someone who's unsafe, the lease is broken for everyone who stays there. And we'll talk about how that can be a little bit complicated sometimes as you're kind of navigating that. But it is important to know as you're talking with folks that the lease is broken for everyone. And then this is the final one, I guess. The lease break cannot be backdated. So if I am a victim survivor of violence, I have fled, I'm staying with friends or family, I'm in a shelter, wherever I might be, I still have the opportunity to break my lease, but it has to be like now into the future. I couldn't backdate it to the day that I actually fled the unit. It has to be any time from present moment to another date in the future. So just keep that in mind. But you can flee for your safety first, and then as you're kind of making your choices about what makes sense, you can decide to break your lease after that. This law, of course, is a Minnesota statute, so it only applies to residences here in Minnesota. And it doesn't matter what kind of housing you have. So it could be that someone uses the Minnesota statute and they have Section 8. So that's why it gets a little bit confusing. So market rate or federally subsidized rent or places would be eligible to have their lease broken with this statute. But again, always, always, always look to VAWA first. Explore those VAWA options. And the reason for that, again, is one, VAWA has a couple more options available, depending on what the victim survivor wants and needs. And two, depending on the type of housing the victim survivor has, if we're breaking our lease with the Minnesota statute, it could mean that they lose their housing subsidy or their subsidized housing kind of going forward. So we always want to be in touch with housing providers for folks that are in federally subsidized housing units. You can still use 504B.206. It might be possible that your subsidy continues, but we have worked with folks where that has not been the case, and that was not a fun conversation, I can guarantee that. So that is kind of the basics of the Minnesota statute, and we'll definitely be diving in a little further. So I kind of think about 504B.206 in 5 steps. So we'll kind of talk through them kind of one by one. If you've worked with folks and used this statute, please feel free to throw other pro tips that you have in the chat too, because we're always learning and always trying to make this easier for folks. But I think about preparing folks, gathering documentation, notifying the landlord, paying the rent, and moving out. Those are kind of the 5 steps. Sound way more simple in a list like that, because even if we're moving for really happy reasons, it's still a lot of work. So we'll dive in a little bit and kind of move through the statute. So first is preparation. So we are advocates. We are always talking safety planning and we're always talking about options. So we, of course, are going to be talking with the victim survivor about where are they going to go once the lease is broken. So it might mean, maybe they want to break the lease tomorrow. They're going to stay in a shelter for a while and go stay with friends or family. Maybe they want to break the lease in January, and January might be a better option for them because they have a housing opportunity in January that came up or whatever that might be. So always thinking about where they're going to go. Always making sure that we're talking about the loss of the security deposit. They're not going to get that back. That is just going to be gone. So making sure people know that, because a lot of times people are relying on the return of their security deposit for a deposit on a future place. So just making sure that folks are really clear that that is going to be gone. And then again, talking about what does it look like to break the lease for all of the other tenants or roommates or occupants of that home. So if they are living with maybe their mom and their brother, do they want to have a conversation with their family about breaking that lease first? Or what does that mean? How is that going to impact their relationships going forward? We've definitely worked with folks who have experienced violence. They have lived with just kind of roommates that they're not super close to, and they didn't want to talk with them about that. And of course, plenty of folks who live with the person who is harmful to them. So there's kind of different scenarios, lots of different scenarios other than those 3, of course, too. But what does that mean? And who are you going to tell about it? We'll talk a little bit about confidentiality too from the landlord perspective, but for now, just thinking about what does that mean? And then what about moving? Where are you going to bring your stuff to? How do you safely get your items out of that home? Are they going to be stored in a storage locker? Can you take them with you? Are you leaving them in the unit and then paying for disposal fees? What does that look like? And then, of course, all of our good safety planning and other additional community resources. This is a really good time to think about safe at home. Maybe an order for protection is a better option than thinking through a lease break. You know, an order for protection could remove that unsafe person from the home. And maybe that's a better option. So just kind of talking through what's going to make the most sense for folks as they're kind of navigating this. Then, if we're thinking about step 2, this is where we have to get the documentation together. So like Bailey was talking about, when it comes to VAWA and certification, there is some documentation that we have to provide under the Minnesota statute as well. So there are 2 main pieces of the documentation that we need. First is the notice to end lease due to fear of violence. We'll have our template linked here. It's from Law Help Minn, I believe. And it is very basic and just, has the name and date of the tenant at top and tells the landlord, hey, I'm breaking my lease with this statute. I will be moving out of my place on this date. And here's what you can do with my stuff when I'm gone. So the form itself, very basic, very easy to throw your name in. Awesome. Super simple. We like easy. The second piece is something called a qualifying document. And this is essentially something showing that domestic or sexual violence has happened or occurred. So there's a couple different things that you can do. First and foremost, for folks who have a protective order, so OFP, HRO, DANCO, whatever that might be, that can be enough. That can fulfill that qualifying document need that the statute requires. You can also have a document signed by a court official or law enforcement. I personally have never had anyone do that because I tend to prefer the statement from a qualified third party, which is something that most advocates use, and I tend to prefer this one as well. But of course, the document signed by a court official or law enforcement is totally acceptable, part of the statute, and absolutely will work. I just tend to prefer the statement from a qualified third party because it's super easy. Again, the template is linked there. And if it's helpful, the language is straight out of the statute, so you can look at the actual statute itself and put that onto your letterhead. You don't have to put it on letterhead, but landlords push back on that. And the statement is nice because it doesn't give the landlord a lot of information about what happened or what kind of violence or who did it or anything like that. It doesn't share any private information like that. And it kind of adds a bit of professional oomph behind someone's lease break, saying that they have had connection with another professional who understands that they've experienced this type of violence and need to flee for their safety. And that qualified third-party statement can be filled out by advocates or a licensed healthcare professional. And we did change the statute a few years ago, so you do not have to have in-person contact with the victim survivor. You just have to have provided professional services too. So I work with folks to break the lease, even though we work with people over the phone. So I think that it takes like 5 seconds to write a qualified third-party statement. It's really simple and can be really easy to do. So enough of that. I like to plug that one a little bit more. But these 2 pieces are the only type of documentation that you need to provide to the landlord. So the notice to end the lease and one of those qualifying documents. And that's it. Landlords will push back on saying an HRO was not something recent enough. That's not accurate. You can have as long as the HRO is active, you're good. We've had landlords say that the qualified third-party statement wasn't on letterhead, so it was made up. Just put it on letterhead. It's okay. So there's different things that landlords will do, but by statute, these are the only 2 pieces of information that you have to provide. Finally, step 3 is landlord notification. So just telling the landlord, if you are doing that on behalf of the victim survivor, fantastic. Just make sure that you get that proper release of information, or the victim survivor can do it as well. Because I work with attorneys, written is always best. It has to be done in writing anyway. Email is great. There's a document trail there, which is perfect. You can also mail it. You can also deliver it in person. Or some language that was added recently is any form of written communication that the tenant regularly uses to communicate with their landlord, which does include texting, if it's something that they kind of regularly use. I tend to prefer email. If someone wants to do it in person as well, I might also offer to do it via email myself.
And one just interesting thing to note is that regularly uses to communicate can qualify a lot of things, not just texting. So it really depends. But we've even heard from tenants who use Facebook Messenger to primarily communicate with their landlord. And if that is the way that you communicate to let your landlord know I paid my rent or I need a repair done, and they frequently and regularly respond, that can be used as well. So just know that there's flexibility in that. I wouldn't extend it too far if it's too estranged, but if that's the common method they use, then that's more than acceptable under the law.
Yep, absolutely. So really, it's about making this accessible for folks, which is great. It does get hard if you have one of those landlords who lives in Florida and doesn't check their email all the time or whatever that might be. So it does get a little bit, it feels less clear that way, but as long as you're communicating in the ways it normally would, or by mail, in person, or email, you're good to go. Remember that the victim survivor can end their lease at any time, so that supersedes any kind of termination notice that might be in the lease. So a lot of times people have to give 60 days or 2 months notice or whatever to break a lease. Not true in this situation, which is great. And then make sure that you're keeping a copy of everything. A lot of times when we're having callers reach out after they've broken their lease and they're having difficulty with their landlord, we always say, hey, show me what you sent the landlord. Let's start there. Let's look at that documentation. So always keep those copies and those texts, those emails, whatever that might be. And then that will be super helpful kind of going forward. And if you do give this paperwork to the landlord in person, take a video of yourself doing that. And again, I would also send it via email just to verify. But again, in person is absolutely acceptable. Harder to keep a trail of. That's the only thing. All right, so step 4, pay the rent. Depending on what day of the month it is, that might have already happened, which is fantastic. But it's not prorated, unfortunately, so you do have to pay the full month's rent. Just as you always would, keep copies of receipts. Get receipts, particularly if you're paying in cash, or things like that. So getting receipts of that rent being paid is really good. Any previously owed rent would still be owed. So let's say I was behind on rent and I broke my lease today, I would still owe money that I already owed. I'm not getting out of that in any way. But I wouldn't have to pay future rent, so I wouldn't owe for December. And then as someone moves out or as they have been given a ledger, always being looking out on the lookout for any kind of property damage. So we'll talk about this on the next slide too, but property damage is kind of a difficult and common issue that folks are facing at the moment. But step 4, pay the full rent. And then final step in my way of thinking about this is that the victim survivor moves out. And as much as possible, treat this like a regular kind of standard move out as you can. So thinking about cleaning the unit, taking all of your belongings with you, taking the trash out, wiping down the counters, kind of all of those sorts of things, as much as possible. Not always the safest thing to do, so be sure you're talking with the victim survivor about what is and is not safe. And then because once you've left a unit, it's hard to prove what damage was done, or maybe there are other roommates that are still living there. Take photos and videos of that damage, especially if there's damage, but take videos and pictures as much as you can anyway, because then you can make sure that you have kind of some photographic evidence if there was any damage. If there was any damage due to domestic or sexual violence, that's something that you'll want to tell the landlord about as well, because you should not be charged for that kind of property damage. I say should not because it shouldn't happen, but it does all the time. So again, when the victim survivor receives a ledger after they've moved out of like cleaning fees or whatever kind of is showing up the landlord is charging them for, be on the lookout for property damage. Again, there's kind of some conflicting viewpoints on how the statute is worded about future fees that could be paid or should be charged after someone moves out. And damages is more of a difficult one sometimes to kind of win, especially if things have been sent to collections. So do what we can up front to try and avoid any kind of conflicts over property damage as much as possible. And that's where those pictures can be super helpful. And then turn in the keys. Once the victim survivor has moved out, turn in the keys to staff in the office, in the Dropbox. I've even done it myself where I've had to stick the keys under the door of the unit, take a video of yourself doing that, and email that to the landlord so they know. But getting the keys turned in, or key fobs, garage door openers, whatever you might have to access the unit, turn those into the landlord. And then finally, again, safety plan throughout this entire process because moving out is a huge amount of work for one, and two is a huge safety risk because you're kind of in a vulnerable space at that point in time. So doing all kinds of safety planning with the victim survivor when they're doing that move out process. Bailey, I wasn't always super clear on the property damage part. Did you have any clarifying advice there?
Uh, only, I mean, 100% documentation is a huge asset, right? Because if they're asserting that you ruined carpet and you scratched up walls and you have a video showing the unit clean as of the day of move out, right? That's a really easy way to start contesting that information and hopefully, if it results in a case, to convince a court that they're being wildly unreasonable with that. Um, my general advice is if it would be a reasonable damage, best practice for landlords, and in my opinion, most ethical practice, is to deduct those damages first from the security deposit, right? They get to hold on to the security deposit. So, like, let's deduct those from it. That's not necessarily a requirement under the law, although I think it's best practice. So they could pursue you for additional damages. If they do, like Raylene said, if they're related to domestic violence, that shouldn't be a penalty, right? We've had individuals who have told us that there was gun violence in their apartment and that a landlord is trying to charge them for the damage resulting from gun violence against that person. That would be penalizing them for being a victim of something someone else was doing, right? But if it's more reasonable damages, for example, if you have paint chipping everywhere because you had a ton of posters up, and I'm not talking regular paint chipping, I'm talking the wall is as speckled as can be, right? They might be able to charge you for something like that, where it's like, that's not a reasonable use of this space and a reasonable use that I have to repair. If it's regular wear and tear, like there's a few extra scrapes on the wood floors, that's not going to qualify, right? It needs to be something where, like, by reasonable efforts, you should have prevented that or you should be on the hook for it. So it's hard because you kind of have to argue and nitpick. But again, it's good to know that there are some damages that I might be on the hook for, and there are some damages I definitely should not be on the hook for. That's how I would handle the situation.
Beautiful. Thank you for that. That's a complicated one sometimes, and people may or may not have the energy or capacity to push back on that. But this is where we as advocates can be super helpful. So communicating with landlords is a big thing that we can do to, again, kind of add our professional oomph behind some of this stuff, and to teach landlords, quite frankly, about what this process looks like. Because many might not have engaged with this statute before. They don't always know how it works. Maybe they have information about how the statute used to work years ago or something along those lines. So this is where we can help be really clear about what this statute allows. We can provide copies of the statute, the language, and send that right over to the landlord. We can assist the victim survivor in submitting the documentation. We've had folks break their lease because they were afraid of their landlord, and then the victim survivor might not want to have communication with the landlord. So we can do that on their behalf. Again, with an appropriate release of information and all of those good things. We can also be really clear about what that move out plan looks like, and confirming things with the landlord and really assisting kind of generally in that moving process. And the biggest thing I think that gets kind of tricky for victims and survivors is the property damage and charges after they've moved out. And once you've turned in documentation to your landlord breaking that lease, there's not really a confirmation process. And so sometimes victims and survivors feel like, is it broken? And the answer is yes, as long as we follow the statute, but there's often questions. We can also be helpful making sure and checking on Minnesota court records online to make sure the landlord didn't file an eviction action against the victim survivor. And we've also had an increase in landlords just saying no to a lease break, which is not allowed either. So again, we can provide statute documentation to the landlords and really remind them this is something that the victim survivor has a right to do, and you don't get to not allow it, if that makes sense. And when that is getting difficult, reach out to us and we can help talk you through that for sure. Because we got to have full chest advocacy in these moments sometimes.
All right, so it's time to test our knowledge a little bit. First, we're going to review it. We're not going to put you to the test right away. And then we'll have a section with a few hypotheticals where we can apply, hopefully, what we've learned. Obviously, I think you are not able to turn on your video. So any participation, questions, throw a reminder just to throw them into the chat, as that's what we'll be monitoring. So, first and foremost, protections offered by these two different and distinct laws. VAWA has to be in federally subsidized housing, right? That is the requirement at the forefront. Minnesota applies to all residential tenancies, right? So VAWA is very specific to who it provides relief to. Minnesota, if you live in the state of Minnesota and this is your residential address, like the place where you live, you can use this lease break process. For VAWA, the qualifying incident has to be either domestic violence, dating violence, sexual assault, or stalking. It could unfortunately be a combination of those things. You only need one to qualify, right? But victim survivors might qualify in a number of categories for unfortunate reasons. Minnesota's statute is a little different. It includes domestic abuse, that's as domestic abuse is defined in Minnesota, criminal sexual conduct, sexual extortion, or harassment. So they sound a little similar, but they have more specific definitions that kind of separate those things, right? So it's very good to keep an ear open when you're listening to a caller or a client and talking to them, and kind of be flagging in your mind, would this fall under VAWA? Do they have a housing subsidy? And does the incident they experienced qualify? If not, would they be eligible for 504B protections because they've been a victim of these certain things, right? Next, what can we do, right? Once we've determined if they qualify, what relief can I actually get? VAWA does not end a lease, it changes, alters, modifies a lease, right? In technicality, it could, with an emergency transfer, end a lease and restart it somewhere else, or a lease bifurcation, right? But the process is that the housing subsidy is following you, right, at the same time, and it's all supposed to be a little bit in flux. So I like to think about VAWA as not ending a lease, but like Raylene said earlier, changing the terms of the lease or changing where the lease is. Lease bifurcation can remove an abusive party from the victim survivor's lease. So if they don't want to live with their abuser anymore and they'd qualify under VAWA, they could ask their landlord for a lease bifurcation, and that would require the landlord to separate the lease between the two people. It's kind of like a partition action in real property. I do not throw that out there to confuse you more. So if you ever have questions on partition, feel free to bother me as well on that. Emergency transfer, again, another option under VAWA. This is where I'm saying I need help getting out of this apartment and somewhere safer. It is not as immediate as the word emergency sounds most of the time. However, it does allow you to stay in one place and set up new housing somewhere else where you're going to feel safer, right? And that is a good goal for a lot of people. It also allows you to stay in your residence. They can't remove you just because of your status as a victim survivor. So if you want to keep living there and that is the remedy you think is best for you, that's something you could assert a right for under VAWA. Minnesota 504B.206, the lease is done, right? It's not changed. It's not modified. It is ended by the date provided in the notice you give your landlord. It is terminated for all tenants. That goes for an abusive party who's also on the lease. That goes for college roommates. That goes for a child who would be an authorized occupant under the lease, right? The lease is done. It does not continue. The landlord can enter into a new lease with any remaining people who are still there, but the victim survivor would not be a part of that lease, would not be liable for any of that lease, and that is at the landlord's kind of discretion or approval, right? So if you were working with someone and a lease was broken under 504B and you were concerned about what they might do, they could re-sign a lease, but they might be on the hook for a higher rate if they stay. So that is a conversation to have. The landlord and the remaining tenants, like I said, can enter into that new lease. Doesn't include the victim survivor. There's no financial penalties. So the statute specifically says there can't be penalties, like we were talking about with damages. If they're reasonable, that probably wouldn't be determined as a penalty. That would probably be just that's your responsibility. It would be your normal responsibility under the regular terms of the lease, too. But there can't be additional penalties imposed on you, right? They can't say, well, now I'm charging you a termination fee. Nope, that's not allowed under the statute. That's not allowed. So they can't do that additional penalty. And it's important to note that for victim survivors because not a lot of people always understand what I can and can't do for these rights. So that's the difference. One ends a lease, one changes a lot of the parts of the lease, whether that's location or who's on the lease. And that's the way to think about the differences between what they can do. All right. So for documentation, again, they're different, but they kind of maybe resemble one another. For VAWA, can be verbal, not my preferred option if possible. If written, can be the HUD self-certification form, can be a record of a law enforcement agency or court, can be the Law Help MN form, right? Basically, the documentation needs to show that you're a survivor of this kind of violence. If you have questions about that documentation, feel free to reach out to us. We are happy to answer those questions. 504B, though, is very specific on what documentation to provide. It's not hard, it's just very specific. The notice to end lease due to the fear of violence, my recommendation is either use our template or Google the statute itself, right? 504B.206, and copy and paste the language that says the tenant needs to state that I am ending this lease due to fear of violence. Here is my address, and just fill in that information the statute has. That's the way to make sure you're capturing all the right language and just edit as it applies to this unique person or your situation, right? The things that are needed to be included are that the tenant needs to terminate the tenancy, they fear imminent violence from a person in the qualifying document, the date on which the lease will terminate, and written instructions for the disposition of remaining personal property, right? What to do with my stuff I leave behind. You should put that provision in even if you're not planning on leaving anything behind, just to make sure you're comporting with the statute. As for the qualified third party statement, that is again proscribed by statute, but has a lot of options. Qualified third party statement might be the easiest when an advocate is involved, right? Because you're able to do that on behalf of a victim survivor and it's limited documentation. But victim survivor is also able to use an order for protection, an existing harassment restraining order, a domestic abuse no contact order, some other no contact order, law enforcement statement, court official, tribal official, right? There's a lot of options. And if they're like, I don't care that my landlord knows the information in my OFP, I don't want to waste any time, I have a copy of it right now and I want to provide it, that's enough. That's sufficient. So they're more than able to do that if they'd like to. And the other important distinction is that this notice can be provided at any time before the move out date. The imminency of the violence might be questioned if you provide notice to end a lease in March from now, right? That might be a concern unless you can show that an offender is being released from prison that day or something like that. I might encourage someone to wait to break their lease under those circumstances. But there's no like specific time prescribed in the statute. You can technically terminate your lease on the last day of the month in your the last day of the month, and then it is still effective as long as you provide the required documentation and you paid rent for that month and you're out by the first day of the following month, right? So I wouldn't necessarily advise that timeline if people have extra time, but I also know this is for emergency situations. So if the situation warranted it, that is allowed under the statute.
And on those last minute, like last minutes of the month kind of energy, make sure we're emailing because then there's a timestamp on there. We like that.
Very true. Very, very, very true. So the process, right? For VAWA notice, it can be a long time for some things, right? Once I've been certified, great, but then it might take a little while to bifurcate the lease and find a new unit. It might take a minute to do these other things. So safety planning is really important during that time period. And there might not be some safe options given a victim survivor's limited circumstances, right? Housing stability is a big, big issue for a lot of people right now, and especially for people who are victims of violence. And so, that is something to be mindful of, that they might not have safe options right now, but we need to try to look for them or plan for future safe options that we can use when it's appropriate. Another important thing that is something you wouldn't think you'd need to worry about, but you definitely do, is that you can't have two federally subsidized units at the same time. So the move, once it happens, if you did move out of your unit, has to happen quickly, right? You can't be paying for a lease here for a month and then also having a lease here at this month and having the same subsidy. That could be considered fraud, and I would not want someone to get into that circumstance. So make sure that that is not happening. It's a little bit of a frustrating process, but again, it's just to make sure that the transfer is smooth as possible and doesn't present future problems for a survivor. For 504B 206, there's no notice period required. Like I said, you can break the lease at any time. It could be the day before the month ends. It could be the first day of the month to January 30th. Or January. It's not even December yet. That's just what I'm thinking of with the new year. But you can, right? You can break it at any time. The concern is just that imminent language that's required by the statute. If a landlord were to challenge it and say, I don't think this is imminent, the circumstances will kind of dictate that. So my advice would be doing it within the month that it's going to happen or the month prior if you absolutely feel it's necessary, right? You have time, you have options, and so you don't need to start that process right away if you're not certain about it. Rent is due for the month in which the tenancy is terminated, as the security deposit will be forfeited. It's the same amount if you terminate the lease on the first of the month or the last day of the month, like Raylene said. There's not a prorating system. Yet we are open to ideas to improve the law, and we're engaged in a lot of discussions with other coalitions and organizations to address that issue. So feel free to suggest things to us because we're always looking to improve our existing laws. And there's not additional penalties again. You can't penalize someone for doing this. You can only do what would be normal and reasonable, which is that security deposit and then like reasonable damages that would be expected under a normal situation. All right, finally, confidentiality. VAWA has a strict right? It has to be kept separate in a different system. It has to be separate from their general file. That is VAWA. 504B.206 is a little less regimented, but has the same spirit. Landlord can't disclose information that was provided to them, so they can't verify if someone said that they're a survivor of violence, right? If someone else in the apartment says, oh, I heard Barbara moved out because of a bad situation with her ex-boyfriend, landlord cannot say anything about that, right? He cannot provide any kind of information about that person's status as a survivor, right? He could say, oh yeah, she did move out, and that would be it. That's all that they could release about that person. You can't provide the address or location of the tenant's relocation under this. You can't provide the status of them as a victim survivor. And you can't provide any of the information in that written notification. So if you provided, I'm really afraid of this specific person and I don't think he should be allowed around the apartment complex anymore, the landlord is not allowed to like necessarily release other information to other people, but they could use that information to keep people on the property safe if there were concerns about that, right? It does prevent a little bit of a problem for landlords because obviously if you have a group of 4 roommates and one person terminates the lease due to fear of violence, the landlord can't tell those people that the lease was terminated due to that reason, right? He's restricted or she's restricted in that ability. And so that's one of those things that we are trying to problem solve right now to see if there might be a legislative solution, but that is a kind of uncomfortable part of the statute right now that hasn't been resolved. And again, information about this person as a survivor cannot be entered into other things. There are some limited exceptions. For example, if you needed to evict a person who overstayed when they said that they would vacate the apartment in that initial notice, right? In an eviction proceeding, that you could use some of that documentation to show that they did not move out when they said that they were going to move out. Same thing for an action for unpaid rent, right? They can pursue unpaid rent against a tenant. It can't be after the lease was broken, right? As the gentle or maybe aggressive reminder, because that seems to happen a lot. But it cannot be after the lease was broken. It has to be unpaid rent before the lease was broken. And then claims under 504B.178 with the consent of the tenant or as otherwise required by the law, right? There might be other limited exceptions, but these are the general things that they would be able to release that information in. If they violate, could be $2,000 in damages, right? So there is a strong incentive to keep this information protected and private. There's a strong incentive to follow this law and not violate it so that there cannot be damages assessed against you and possible attorney's fees. So that is important again to note. It's a good bargaining tool or negotiating chip. Sometimes if landlords don't realize they're wrong and don't realize that this could have financial consequences, it's good for them to know because maybe they'll assess the situation a bit differently. But also, it's good to know for survivors that people are not going to be releasing their information to the world, right? They're not going to be doing that, so that information will be protected. All right, it is time to stop listening to me yap and to practice a little bit. So again, if you could use the chat function, we would greatly appreciate it because Raylene and I, shocker, already know the answers to these hypotheticals because we wrote them. So, Raylene, do you want to read the first one?
Absolutely, I would love to. So, our first one situation. Teresa calls your office and wants to get out of her apartment. She tells you that she had an abusive partner 3 years ago and she thinks he may have found her new apartment address. So, given the basics of that phone call or, a walk-in or whatever that might be, what kind of questions would you ask Teresa to find out what options she might have as it relates to her housing?
And we'll give you a few minutes because I know you can't just interrupt us and raise your hand like in a regular proceeding. So I'll wait a few seconds to answer. I also, if there's any Real Housewives fans on here, I used Teresa Giudice from the Real Housewives of New Jersey for this example. It's not based on her real life. I just needed some names. So in case anyone was wondering, that 100% is what happened there. All right. What do we think? What questions should we be asking Teresa in this situation? Raylene, what's the first question you would ask as someone
Yeah,
looking for this
that's
info?
a great question. I am an advocate, so I want to know about safety first and foremost. Do we need to, yeah, see, yep, Nikki's got it. Absolutely. Great work. Absolutely. So I'm thinking about safety. So we're going to do any kind of safety planning, shelters, family members, wherever. Where are you going if we're not feeling safe in the home? But in terms of legal options and kind of what things she might have going on, I am probably going to want to find out what kind of housing she lives in. So I might want to think about, is she living in subsidized housing or is she paying market rate rent? That might be a place that I might start.
I think those are great places to start. Um, One of the other things I would be thinking about is also would this person qualify for any protective orders, right? Do they need to flee or do they want to stay? And if they stay, how can we do that, like we said, in a safe way? So does she feel the need to go somewhere else? Is she able to? Because like I said earlier, sometimes we don't have super safe options, right? Sometimes the option is between staying in an unstable like situation with someone who's harming you or not having a place to be at all, right? And that's a hard choice to make. um yeah, we have some other ones. Does she have children to consider? Another good one. A lot of parents make very different decisions when they're acting on their kids' behalf than they might if they didn't have to worry about their kids, right? How is that impacting their decisions? And how can we plan for that, right? I'm not going to counsel someone to leave their children behind unless law would require it for some reason or the children would be safe. That's the big thing. Would she consider a shelter? Great question. Again, some people are more than willing and open, and we have a lot of great domestic violence shelters here in the state of Minnesota. They're unfortunately almost always at capacity, if not always at capacity, but great resources, especially if there's an open place. Is it subsidized housing? Exactly. Does she have VAWA options, or are we just talking 504B options? For safety, is she wanting to leave her apartment immediately? Yeah. Is she wanting to leave right now, or is she saying, no, I'm okay for a minute, but I do need to figure this out because I'm scared, right? I do need to figure this out. Does she have transportation? Great question. How does she leave? How would she leave? Is there an apartment close by to her that she could find that would work for her? Does she have access to move? How can she move, right? And these are all things that you don't ask right off the bat. But one question, as you can see, prompts a bunch of other questions that give you great information for you to say, oh, I know a domestic violence shelter that would be super helpful for you and your kids right now. Or, oh, I actually know a housing provider near that area. I'll, maybe I can reach out to them and see if they have any open units and see what that looks like, right? It's great creativity. All right.
Next one. Great work, team. Our next example is coming. There we go. All
Perfect.
right, so Simon was sexually assaulted by someone at a college party this past weekend. Simon lives with three of his good friends in student housing near his college and has started having nightmares and worrying that the person who assaulted him will figure out where he lives and harm him again. Simon does not have a federal housing subsidy, but he wants to move ASAP to a new place. He does not want his friends to know that he was assaulted. So, what options might Simon have in this situation? There's always so much to think about in these scenarios, and we're only giving you a little hint. Obviously there's a lot more when we're talking with folks, there's always a lot more background, a lot more context, thinking about people's identities and how that plays into the situation. Lots to think about, but let's see here.
Does he know the assailant? Has law enforcement been involved? I mean, those are good questions. Here is something where he doesn't seem to have a personal relationship really with the assailant, and it doesn't seem like he's, sought help outside of maybe figuring out what's going on right now. So based on that, what options do we think he might have? And there's kind of some specific details here that are going to cue you towards one option we've talked about today and not the other, hopefully. Right, so Simon's trying to figure out, what do I do? I don't want my friends to know what I've been assaulted, but I'm scared to stay in this apartment. What can I possibly be doing?
Yeah, Simon is looking to move.
Any thoughts? All right. Okay.
Lots of things going on here. Absolutely. Lots of things to think about. I think for me, I'm cued into Simon doesn't have a federal housing subsidy, and wants to move. So thinking about shelters, absolutely important as we're kind of navigating the moving process. For me, housing is my background, so I'm always thinking about my favorite statute. So I'm thinking about 504B.206 for sure in terms of moving. There's plenty of other advocacy options to explore. We're just going to kind of hone in on these housing pieces here. So there's lots of things going on, talking to people in student life, campus counselor, things like that. Always, always good. We want to do good advocacy to get people connected to these resources. But Simon has said that they want to move, so that's what I'm gonna start with is that moving piece. And shelters and all of these other resources are definitely a part of that. But I want to make sure that I talk with him about the lease break process.
That and I think it's important to figure out the options, right? So he doesn't have a subsidy. VAWA is not going to be an option under these circumstances for housing,
Mhm.
right? I'm not saying it couldn't apply in a different way, but for housing options, VAWA is not going to be applicable since he doesn't have that federal housing subsidy. However, because Simon lives somewhere in Minnesota at a college, right? 504B is an option, 504B 206. And maybe that is the option we go with. I also think with student housing, it is a great idea to talk to someone in campus who, if they are in charge of student housing, to see if there would be an option for a transfer internally or something. Maybe they already have an internal process where Simon could continue his same lease obligation but move to a different place safely, right? That might be an option. It might not be, but it's good to know, well, do I have to break a lease? Is that where we're at? Because that might be the only option if people aren't willing to be flexible. And if so, what does that look like? But yeah, I think Simon's options are probably to either break his lease or to figure out some kind of arrangement with the housing provider if they're, willing to help out since VAWA wouldn't be mandated upon them. All right. I can read this one. So we have Stevie, who lives in Brooklyn Park, and they have Section 8 housing. They want to move out of the Twin Cities metro area up north where their family lives because oh, and we missed a space there. Stevie's landlord has started acting odd and said that Stevie doesn't have to pay rent if they give their landlord sexual favors. I put that in quotes so you would know that we think that that phrase is gross, but we're putting it from a gross position of someone with a sexual proposition that's inappropriate. So just know that. Stevie does not want to wait long to move and is not worried about losing their housing subsidy or security deposit because they're able to move in with their grandma. They said, I just need to get out of this apartment, move up north, get my family support. I'm really afraid my landlord's being weird. Would you think that Stevie could use VAWA or 504B.206 to accomplish the goal that they have? And that's the key phrase there, to accomplish the goal because they want to end their lease and move. Which option would Stevie use in that case? Any guesses? Feel free to be wrong too. I will not chastise anyone for waging a good guess.
I learn more when I do it wrong.
That sometimes is key. What do we think, everyone? VAWA or 504B.206?
To be fair, we tried to trick you a little bit with this one. So it is a little bit complicated. So Bailey, what would we look to first in a situation like this? How would you approach it?
Well, first, I'd want to know about the housing subsidy, which I know about, right? So they have Section 8, which means I have both VAWA and 504B as options, right? Because if I don't have my federal housing subsidy, then I am limited to 504B.206 to change my lease up, right? Or not change, end my lease. But if I do have housing subsidy, then I have both options because I live in Minnesota and I am under the jurisdiction of the federal government in Minnesota, right? So I have both options. Now I'm turning to what is this person's goal, right? What is this person's goal? Stevie said, I don't care about continuing my subsidy. I do not care about it. I have a safe place to land. My grandma will welcome me in with them. I just want to get out. And when I hear that, I'm not hearing I want to change my lease. I'm hearing I want to be done with my lease. And when I'm hearing that, right, I'm thinking 504B.206 because VAWA could change it, but Stevie doesn't care about changing it. Stevie just wants out to live with their grandma. It sounds like that would be a lovely, safe environment for them up north. So that's what would be the option I would be telling this caller about. I'd say 504B sounds like what you're trying to accomplish here. Here's how you would do that.
Yeah, I think that's perfect. I think as an advocate, I'm going to have that conversation of if we do break your lease, it is definitely a possibility you're going to lose that subsidy, and we want to be super clear about that. Stevie's fine with that, but I always like to make like have a good conversation around that, just because getting a housing subsidy in the future is like years and it takes so much time. So like we just want to be super clear about what that means. But 504B.206 is the way to end that lease and get out of that place and go move in with grandma.
All right, and we only have a couple minutes, so maybe Raylene and I can just cover these a little bit. But if a client comes to you and wants to move, what documentation would be helpful to see what options they have? Raylene, what kind of documents are you looking for when someone tells us they want to leave their residence?
Yeah, so again, first I always want to find out what kind of housing do you have? Do you have subsidized housing? Do you have market rate housing? And what are we trying to do? What are your goals? Like Bailey was saying, are we trying to change our lease? Are we trying to end our lease? And when it comes to VAWA, I'm going to use like the HUD form, so Form 5382 or the Law Help Amend form. If it's documentation for 504B.206, I want to look to that notice to end lease due to fear of violence and a qualified document. So probably in my case, always recommending that qualified third party statement is what I'm looking for.
Yeah, income, that's also good to acknowledge, right? If they have available income, housing assistance, I definitely would love to see documentation on that. If they
Mhm.
have a negative background, I might want to know about that too, because maybe it's not good to end their lease because they kind of got lucky with this landlord that they didn't check their eviction record, right? And we don't want to put them in a spot where they're not going to have housing at all. And so maybe it's not going to be best to break their lease. And that would really guide advocacy goals, right? So those are good suggestions. What questions might you ask a client to better understand if they would qualify for VAWA protections? Like Raylene was suggesting earlier, sometimes requesting to see the documentation can be helpful, but sometimes also just saying like, do you get help with your rent every month, right? Did you have to apply for that help? Do you know where that comes from? Do you have documentation to show where that comes from so I can read it? Let me pull up the HUD website and see all those forms and see if the document matches, right? There's plenty of questions to get that information. Um, I find that when people understand why I'm asking questions like that they are super willing to volunteer that information, right? It's a little odd to say, um, hey, what's your housing subsidy? Or hey, what is this? But if you're like, hey, I actually, to understand your options better, it helps me to know like how you actually pay for your rent because there's certain options that might extend to you if you have a housing subsidy. And then people are more than willing to say, well, I don't know, but here's all the stuff I know about it and you can figure it out together. In my experience, at least, people seem to like it when you're just trying to engage and help and understand, right? So those are the kinds of questions I would be asking.
Yeah, and it just provides a good way to bring people into the VAWA protections and help them understand the process too. Because just like we get confused by it, so do victims and survivors. Because a lot of times people will call us and say, well, I have VAWA rights, and we find out they don't apply in this situation. So it helps teach them as well as you're kind of navigating.
Totally, totally. And we'll answer this last one too, just for the shortness on time. So I'll say Alex needed to end their lease due to ongoing harassment and was able to work with an advocate to provide their landlord with a notice to end the lease under 504B.206 and a signed qualified third party statement via email. Her landlord responds and said, the paperwork you sent me does not legally release you from the lease. I'm willing to end your lease early if you pay 2 months of rent and forfeit your security deposit. Raylene, Alex is calling you. What can you say to Alex briefly?
Absolutely. First and foremost, I'm going to confirm with Alex that they followed the statute appropriately. So they provided the correct documentation, they followed all the steps, they did a great job, and that their landlord is incorrect and has a misunderstanding of how the statute works. So we might say, hey, we can provide the landlord with copies of the statute. We can email them and explain the way that this process works. And then if that doesn't work, then I sick Bailey on them. So that's kind of how we do it here. But again, a lot of times this comes with like being really, really confident and really strong in your advocacy, and telling the landlord, this is the statute. I've had landlords misquote the statute to me, so I correct them on that. So there's lots of different ways that you can do it because we're trying to balance that relationship of, not harming any kind. We don't want Alex to have any future like negative references and things like that. And people get really nervous about their housing situation, don't want eviction. So that Alex might have some fear there. But we can always reassure Alex they did it right, and we will help push back with that landlord and explain how this process works and call Bailey when we need to.
If needed. I'm going to skip the last one because I think that's the least applicable, and I want to highlight this before we go. So, Raylene and I are always working on new options and things that would be beneficial to victim survivors. If you can think of something that you think we might be able to help with, feel free to reach out and say, we'd love this resource, or we'd love to further understand this. We are working on a flow chart right now for VAWA rights versus 504B options. And we are hoping to release that soon. So this is just a draft that I have available that we're kind of working through internally to get the cogs out. But we are hoping to have that soon for all of you to hopefully better understand, again, are we in a zone for VAWA or are we in a zone for 504B.206? And with that, here is our information. So feel free to get a hold of us with housing inquiries and questions.
Well, thank you so much for being here today. If we don't have any more questions, then I guess we'll see you again next month with a new webinar. Thank you, Raylene. Thank you, Bailey.
All right. Thanks, everyone. We appreciate it.
Yeah, have a good rest of the day.